The jury deliberated for just under 11 hours. Conventional wisdom calls for, when they deliberate for such a short amount of time, that it's a good sign for the prosecution, and it turned out to be the case here.
Yes. Yeah, this was the best result that the prosecution could have ever hoped for. And I think it speaks volumes about the type of case that they put on and how methodically they presented the evidence so that the jury understood the medical testimony and understood the expert testimony in a way that was digestible to them and in a way that they could process it and render a verdict.
I mean, we're talking about 3 weeks, 45 witnesses, and they were able to reconcile these charges rather quickly. Can you talk about the elements in layman's terms of all of these counts? Because there are a lot of them, and they range from assault to negligence.
Correct. So what's really the most serious charge here that Officer Chauvin was convicted of is the second-degree murder charge. That is, to prove that charge, the prosecution needed to show that he caused Mr. Floyd's death and that he did it. The death was caused as a result of an assault. And an assault is as simple as an unwanted touching that places somebody in reasonable fear. So by placing his knee on his neck, we've got an assault. And then did that assault then ultimately lead to, the cause of the death? And so the jury said yes, that did lead to the cause of his death, and that there is your second degree murder charge. The third degree murder charge is a little bit different, and it's actually very similar to the manslaughter charge that he was also convicted of. The third degree manslaughter charge looks to the penetration of an act that's emanating from activity that's dangerous to others. And you have to show a depraved mind, and you also have to show that you acted without regard, that the defendant acted without regard for human life. So again, here the act of staying on his neck for the 9 minutes 23 seconds, that was sufficient to show a depraved mind and a disregard for human life. The final charge that he was convicted of, the second degree manslaughter charge, is the least serious. It carries the shortest sentence of them. And all that the prosecution needed to show for the manslaughter charge was that Chauvin's actions put Mr. Floyd at risk of death, or at risk of great bodily harm. So that third charge seemed kind of like a no-brainer. I mean, that was going to sort of be, I think, under all the evidence that was presented, that was absolutely going to be a guilty verdict. The first two charges, though, are more complex and require a higher degree of burden of proof on the prosecution.
Let's talk about just how historic this verdict is. When we see situations like this happen, involving excessive use of force by police officers and that resulting in the death of a person or serious injury, charges are rare. Convictions are even more rare. How is this a spark point? How does this change moving forward police accountability?
Hopefully it will spark a meaningful change so that we don't see these kinds of killings happening with the rate that we currently see them at. However, I think the more telling piece of this is how important witnesses are and how important it is to intervene and not turn a blind eye and walk away, because the video evidence here was so compelling and so powerful. And that evidence only came from those bystanders who were trying to stop what was happening. The testimony of that 9-year-old little girl who, in her 9-year-old way, talked about how incredibly horrifying and wrong this was. And as the prosecutor said, in a 9-year-old's words, we heard what's right and wrong, and this was wrong. So I think that's the more powerful meaning here. We can't really say what's going to happen after this verdict. Many people will say this was the right verdict, and I believe that given the evidence that was presented, this absolutely was the right verdict. But is it going to cause a wholesale change in police brutality and police unlawful killings? It may not. But I think it does make people more aware of the impact that you can have as a bystander. You may not be able to stop what's going on, but you can pull out your phone, you can video and audio record, you can share that information with law enforcement and step up in a way to do the right thing, even if you couldn't stop what was happening or unfolding in front of you.
sentencing is set to happen in a few weeks. As you mentioned, the most serious charge being that of second-degree unintentional murder, which carries a maximum penalty of 40 years. How do you anticipate the judge will handle the sentencing?
So pursuant to the Minnesota sentencing guidelines, the judge has the ability to do a range of a sentence, the 40 years being the maximum penalty, 12 and a half being on the lower end. The judge has the ability, he will take into account a pre-sentencing report. He will take into account whether or not Derek Chauvin has any prior criminal involvement or issues. But he also, and probably most importantly here, he has the ability to digress from those sentencing guidelines if he can find that the crime was committed under aggravating circumstances. And under Minnesota law, we've got two circumstances that would qualify as potentially aggravating circumstances here that could lead to Derek Chauvin having a longer sentence imposed than just the 40 years. We've got the issue of the cruelty, the degree of the crime and the cruel nature of it. That's an aggravating circumstance. The other aggravating circumstance is, did this crime happen in the presence of children? And that is another key component of that 9-year-old's testimony, is that we know it did happen in the presence of children, or at least one child. And she was brave enough to speak up and testify. So those two factors would need to be looked at by Judge Cahill when entering his sentencing guidelines. So, 40 years is sort of the sentencing guidelines maximum, but Judge Cahill could order an extended sentence if he found those aggravating factors to be present.
Lastly, do you anticipate an appeal?
I'm sure there's going to be an appeal. I mean, it's almost a matter of course that there's going to be appeal. And in fact, the defense was sort of starting to lay the groundwork for that in any way he could by asking for a mistrial, saying that the jury was not properly shielded from the publicity of the case. So certainly there's going to be an appeal. It's my understanding that in Minnesota, the appeal process could take anywhere from 12 to 18 months, and that appeal, will probably be lodged within the next 30 days, at least the notification of appeal. And then, that will have to work its way through the appeals court.
Would he